Hey guys, Logan Moore here. I'm going to tell you about Gabčíkovo Nagymaros project, Hungary versus Slovakia. This case rose out of a signature September 16th of 1977. The signatories were Hungary and Czechoslovakia. The treaty is hereinafter referred to as the 1977 treaty. The 1977 treaty concerned the construction and operation of the Gabčíkovo and Nagymaros system of locks, which would ensure environmental protection and quality of the river and further the utilization of natural resources of the Bratislava-Budapest section of the Danube River. The 1977 treaty provided for the building of two series of locks, one at Gabčíkovo in Czechoslovakia and the other at Nagymaros in Hungary. This would constitute a single and indivisible operational system of locks. Now I run through the timeline because it's important later on when I go to discuss the issues. On May 13th, 1989, Hungary suspended the Nagymaros works pending completion of various studies. October of 1989, Hungary discontinued the Nagymaros work. Negotiations took place between the two states during this period, and Czechoslovakia began looking for alternative solutions. Now, come July 23rd, 1991, Czechoslovakia began construction to put the Gabčíkovo project into operation, according to an alternative solution that it found, Variant C. Now, in May 19th, 1992, Hungary transmitted to Czechoslovakia a notification unilaterally terminating the 1977 treaty with effect to take place 6 days later. Now, in May 1992, the 25th of May, Hungary notification of termination came into effect, and that's the 6 days later. On October 15th, 1992, Czechoslovakia began work to enable the Danube to be closed. And shortly thereafter, Czechoslovakia began damming the river. Now, in 1993, the 1st of January, Slovakia became an independent state. In April 1993, Hungary and Slovakia requested the International Court of Justice to decide whether Hungary had been entitled to suspend and subsequently abandon the works on the Nagymaros project in 1989. Now, that is the primary issue before the ICJ at this time. Now, the ICJ's judgment, September 25th, 1997, they referred to the Vienna Convention on the Law of Treaties and international custom contained therein. And they first considered the first issue of whether or not Hungary was entitled to suspend and subsequently abandon the works on the Nagymaros project in 1989. Now, the ICJ considered the question of whether in 1989 a state of necessity which would have permitted Hungary to suspend and abandon works that it had been committed to perform in the 1977 treaty. And the ICJ found that the perils invoked by Hungary were not sufficiently established in 1989. They were speculative, and they weren't imminent. And that Hungary had available to it at that time means of responding to these perceived perils other than the suspension and abandonment of works in contravention to the 1977 treaty. Moreover, there were negotiations underway that might have led to other alternatives. Now, as to issue 2, whether or not Czechoslovakia was entitled to conduct its unilateral activity, Variant C, on the Danube River, ICJ observed that the basic characteristic of the 1977 treaty was to provide for the construction of locks as a joint investment, constituting a single and indivisible operational system of works. Now, the ICJ found that in unilaterally putting Variant C into operation, Czechoslovakia, and now Slovakia, an independent state, was not applying the 1977 treaty, but in fact had violated certain express provisions and committed an internationally wrongful act. Now, for issue 3, what were the legal effects of the notification of the termination of the treaty by Hungary on 19 May 1992? Now, the first question was, can a party terminate a treaty in the absence of such a termination provision? Now, Article 56.1 of the Vienna Convention that this court recognizes customary law applying in this situation. Treaty which contains no provision regarding its termination and does not provide for denunciation or withdrawal is not subject to denunciation or withdrawal unless it is established that the parties intended to admit the possibility of denunciation or withdrawal, or a right of denunciation or withdrawal is implied by the nature of the treaty. Now, the ICJ in this instance found no evidence that the parties either intended to admit the possibility of denunciation or withdrawal, or that the nature of the treaty implied a right of denunciation or withdrawal. Now, the grounds that Hungary provided to terminate the 1977 treaty was first the existence of state necessity, as mentioned previously. And as mentioned previously, the ICJ found that necessity is not a ground for termination of a treaty and may only be invoked to exonerate from its responsibility a state which has failed to implement a treaty. Now, next, impossibility of performance. Hungary asserted this as why, or a excuse for why it terminated the treaty. Now, under Article 61.1 of the Vienna Convention, a party may invoke impossibility of performing a treaty as a ground for terminating or withdrawing from it if the impossibility results from the permanent disappearance or destruction of an object indispensable for the execution of a treaty. If the impossibility is temporary, it may be invoked only as a ground for suspending the operation of the treaty. Now, the ICJ rejected the existence of impossibility for two reasons. If there are any economic or ecological issues, the treaty provided for adaptation. That was one. And two, impossibility was due to Hungary's failure to fulfill obligations. So basically, Hungary brought the state of impossibility on itself. Now, third, occurrence of fundamental change of circumstances. Under Article 62.1 of the Vienna Convention, fundamental change of circumstances which has occurred with regard to those existing at the time of the conclusion of a treaty and which was not foreseen by the parties may not be invoked as a ground for terminating or withdrawing from the treaty unless a. the existence of those circumstances constituted an essential basis of the consent of the parties to be bound by the treaty, and b. the effect of the change is radically to transform the extent of obligations still to be performed under that treaty. Now, the ICJ found, under this instance, that change in political nature, the fall of communism, was not closely tied to the object and purpose of the treaty, and therefore did not form an essential basis, nor did they radically alter the obligations under the treaty to be formed, and progress of environmental knowledge and development of new norms of international law were not unforeseen. Now, as to the material breach by Czechoslovakia that Hungary asserted, under Article 60, subsection 1 of the Vienna Convention, material breach of a bilateral treaty by one of the parties entitles the other to invoke the breach as a ground for terminating the treaty or suspending its operation in whole or in part. Now, the ICJ found here no sufficient evidence that Czech refused negotiations. Czech had not materially breached when Hungary issued notification of termination. Now, as for the development of new norms of international environmental law, neither of the states contended that a new peremptory norm of international environmental law existed. Therefore, the ICJ didn't consider it. Now, furthermore, there were some procedural requirements at play, and under Article 65 of the Vienna Convention, a minimum of 3 months after the receipt of notification for the termination to take effect. Now, the court found that Hungary's termination of the treaty was premature. And therefore, in the end, the ICJ ordered that both Hungary and Czechoslovakia had breached their obligations under that treaty.